This is an analysis of a medical review article published by the University of Sheffield that goes over and critiques Charlie's Law and Alfie's laws. Additionally, I am going to explain how benevolence and non-malfeasance were directly involved when creating these policies and how they influence communities. A summary of the article is how it explores legal, ethical, and policy implications of two very high profile UK cases involving the parents of terminally ill children and their medical practitioners. These are Charlie Gard and Alfie Evans. These are Charlie's laws and Alfie's laws. Um, the disagreements stemmed from differing views on whether continuing or pursuing experimental treatments would align with the child's best interests. These cases spurred discussions on on proposed legal reforms, which are called Charlie's laws and Alfie's laws. The key proposals in both of these laws were replacing the best interest test with a significant harm test. Um, Currently, courts decide disputes based on what is in the child's best interest, giving clinicians more of a significant influence over the parents. And additionally, we have mandating mediation in continuous cases. Since there tends to be a lot of dispute between the parents and the medical practitioners and professionals. Finally, empowering parents. Both laws aim to grant the parents greater authority in medical decisions, challenging the dominance of clinical opinions. The role of both benevolence and non-malfeasance in this legal debate were benevolence. We have benevolence, which is the well-being, is going to be resorting to the well-being of the child and also of the child's parents. Clinicians base their recommendations on benevolence, typically striving to act in the child's best interest by minimizing suffering. For Charlie Gard and Alfie Evans, professionals deemed further treatment was futile and harmful, and they argued that withdrawing life support or refraining from experimental interventions would ensure that the dignity and prolonged pain it would ensure dignity and prevent prolonged pain for the child. Proponents of Charlie's Law argued that benevolence should also be considered from the parents' perspective, their well being, and reflecting their intimate understanding of their child's needs. Then we have non malfeasance, which is to avoid harm. The current legal framework supports non malfeasance by prioritizing the prevention of harm, especially when treatment has low chance of success or might increase suffering, which are prevalent in both of these cases. Um, the impact on community and policies. We have distributive justice. Critiques contend that empowering parents to demand experimental or resource intensive treatments could unfairly divert finite medical resources, impacting other patients who could potentially benefit from the proven interventions. This also promoted global standards. The existing best interest framework aligns with the international legal standards, such as the UN Conventions of the Rights of the Child, which prioritizes the child's welfare. Secondly, we have public empowerment. Both proposals highlight the need for better public engagement in healthcare decisions. Mandating mediation and clear resource allocation criteria could foster collaboration between families and clinicians. To conclude, benevolence and non-malfeasance have deeply influenced the legal and clinical framework underlying Charlie's and Alfie's cases. While the proposed reforms may aim to strengthen parental rights, critiques tend to caution that they may undermine the ethical principles that prioritize child's welfare and harm prevention. Mediation rather than legal overhaul emerges a balanced solution for navigating disputes in highly emotional cases.